is Nakirila. I am in 211 Justin Street. I know that I can be allowed here.
You wait to last one. Wait for your chance.
What's your question?
I told you to E219 of 2022. Post out.
My name is Ometo.
Yes.
My name is Ometo.
Yes.
Honorable Tiende Amolo
Pardon?
Honorable Tiende Amolo has already addressed the
Okay. E221 of 2023, Petitioner Law Society of Kenya.
Wait, please, the court. The matter, my name is Theuri. I will address the court for about 5 minutes and then donate another 5 minutes to my colleague, Mr. Ngoloma. Lord, the petition by the Law Society has challenged Section 7 and Section 84 of the Finance Act. I adopt the submissions that have been made with regards to the housing fund. My Lord, I just want to add that in terms of the constitutional test of purpose and effect, as set out in Article 201 of the Constitution, we submit that that amendment fails to meet the constitutional threshold. The fact that, my Lord, Section 84 amends the Employment Act, and the preamble to the Employment Act defines it as an act that seeks to define the basic conditions of employment and related purposes. My Lord, we also have in our laws the Housing Act, which at Section 6 establishes the Housing Fund, supposed to be controlled by the National Housing Corporation. And my Lord, to that effect, we submit that and join the submissions that have been made, the lack of a framework law to anchor those changes that were introduced and the amendments done to the Employment Act therefore violate the constitutional test of purpose and effect and brings to fore uncertainty within the law. Because, my Lord and my Lady, it is not even clear who is eligible to benefit from this scheme in the absence of a framework law. And that goes to also the impropriety of the public notice appointing the Kenya Revenue Authority as the body to administer the housing levy. My Lord, there is also the question of whether the act can be enacted in such a way in light of the provisions of the Constitution, and particularly Schedule 4, that gives the county the function of housing in Schedule 4 and the function of creation of policy to the national government. And my Lord, it is our submission that to adopt any other interpretation would be to give the development of policy a different meaning. And to that extent, we also join in the submissions that were made by Mr. Tiende Amolo that section would in effect be seeking to amend the Constitution. My Lord, for those reasons, we join the rest of the petitioners in imploring this court to find that Section 84 of the Finance Act violates the Constitution for the reasons that we have stated and the reasons that we have stated in our submissions, and to proceed to declare that section as unconstitutional, void, and of no effect, and my Lord, to consequently order that any funds that have been collected would be refunded. My Lord, I cede the floor to my colleague, Mr. Goloma.
Good morning, my lords, my lady. As my president has indicated, my name is Ngoloma. I will be submitting briefly on the issue of whether meaningful public participation was conducted in as far as the third reading introductions, the provisions that were snuck in at the third reading. My Lord, for clarity, these are sections 24C, paragraph 72 and 73, section 44, 47, 5, 100 and 101 of the Impugned Finance Act. Yes. Section 24C, paragraph 72 and 73. Section 44, 47, subsection 5, Section 100 and Section 101 of the Impugned Finance Act. My lords, my lady, there have been extensive submissions with respect to this issue of public participation. Mine is only to address the rejoinder that has been put forward by the respondents. My lords and my lady, the respondents hide behind the standing orders 133 to allege that it allows them to introduce amendments at any stage of the legislative process. My lords, my lady, they further state that the introductions were in fact products of public participation. And on the basis of these two arguments, they claim the same to be constitutional. My lady, that proposition is both factually and legally unfounded and mistaken. First, my lady, on the basis of fact, it is the respondent submission that there was proposals by Sanabil, Kenya Wines Agencies Limited, and Tatu City Limited, as well as KPMG, that resulted in the introductions of these new provisions. In fact, from the report of the committee, it is only Kenya Wines Agencies Limited whose proposal was received and amendments to that effect accepted. My lords, my lady, even just this argument in itself reveals a problematic issue of partiality. My lord, some proposals by the stakeholders were rejected by the Finance Committee for want of public participation, for the very reason that they were being introduced at that stage. My lord, I refer you to page 86 of the report of the Departmental Committee on the Finance and National Planning, where they rejected KPMG's proposal on the basis of the stage at which it was being introduced. Yet, the other provisions that were introduced at the very same stage, they seem to now hide behind and say that they came from the public. My lord, secondly, to demonstrate that they are legally unfounded, that position is legally unfounded, to propose that the standing order 133 overrides constitutional and statutory dictates is a shock to the petitioners. My lords, my lady, in fact, the drafters of the very same standing orders were of the same view that these standing orders must be read in line with the Constitution and statutory provisions. Hence why Standing Order 133.6 clearly provides as what are allowable amendments at the committee stage. My lord, it clearly provides and I will refer this court to the authority in Kenya Bankers Association versus the AG and another. Where the court was very clear that no amendment shall be moved which is inconsistent with any part of the bill already agreed to or any decision already made by the committee. My lord, in fact, the standing orders further say that the additions must be minor amendments and not substantial additions. This is a position that the apex court of this land, my lord, in the BBI case, the AG and 2 others versus ND and 79 others. I'll refer this court to paragraph 270, 302, and 1938 of the Supreme Court's decision. And most notably for this court's understanding, this court simply indicated that there is no evidence of any form of public participation or deliberations between 21st October 2020 and 25th November, when changes to the BBI steering committee draft bill, including the second schedule, was added that show public engagement and consideration of the issue of apportioning and allocating the subject counties, additional constituencies. My lords, my lady, we humbly submit that it is an issue that has been clearly and unequivocally determined by courts, both at the Supreme Court level and at the Court of Appeal record. What is the ambit of the amendments that can be introduced at the committee stage? It cannot be that substantive additions are made in the guise of minor amendments. And to allow such an infraction would be going against the principle of public participation, where Parliament can introduce completely any alien provisions in the guise of introduction from public participation. My lord, last year I will only address the issue of the retrospective application of the law for the period that it had been suspended, and only to respond to the rejoinder given by the respondents. And my lord, very notably, they all hide behind the fact that according to the impugned section 31C that was introduced, the collection period of this housing levy is 9 days after the preceding month. So for them, the argument is that the collection period was after July, so the first 9 days of August. My lord, we are not here to argue on the collection period of the levy. We are here to submit on the date of the effective date and when the housing levy came into force. My lord, for that period there was a conservatory order that had suspended the implementation from 1st of July up until the date that the court lifted the conservatory order. For that reason, it is our submission that any implementation of that provision of the law, of the impugned act, during there was a subsisting conservatory order suspending its implementation, amounts to retrospective application. My lord, my lady, that will be all on my part.
Thank you. E227 of 2023,
There is one last.
No. E227 of 2023.
My lords and my lady, with your kind permission, my name is Ochieng Oginga. I do appear together with my colleague, Ms. Wangui Njoroge, who is present. On behalf of the petitioners, I will be relying on the amended petition dated 31st August 2023, together with the affidavit sworn in support of the same by Raila Amolo Odinga, written submissions dated 31st August 2023, and a list and bundle of authorities equally dated 31st August 2023. I wish to center my submissions on two broad areas, namely taxation and devolution, in light of the Finance Act 2023. Now, the first issue I wish to address is whether sections 2 and 84 of the Finance Act are unconstitutional. And to that extent, I submit that the two provisions are unconstitutional and in contravention of Articles 10, 110, 209, 186(2), and 210 of the Constitution. My Lord, pursuant to Article 110 of the Constitution, a bill concerning county government means a bill containing provisions affecting the functions and powers of county governments. Now, for that proposition, my lords and my lady, I refer the court to be guided by the decision in the matter of the Interim Independent Electoral Commission, that is Constitutional Application number 2 of 2011. That is contained at page 12 of my bundle, and more specifically paragraph 40, where the Supreme Court pointed out and stated, "We consider that the expression any matters touching on county government should be so interpreted as to incorporate any national level process bearing a significant impact on the conduct of county government." My lords. Now, in this case, my lords and my lady, section 2 and 84 contain provisions touching on entertainment tax and the housing levy. My lord, I submit, pursuant to paragraphs 8, part 2 of the 4th schedule, county planning and development, including housing, is a key function of county governments. And the role of the national government is only limited to initiating a housing policy. It cannot go beyond that. My lord, now for that proposition, I invite the court once again to consider the decision in the Law Society of Kenya versus Cabinet Secretary, Ministry for Lands. That is at paragraph 11 of my submissions. Now, more specifically at page 35 of my bundle, at paragraph 54 in that decision. Now, the court emphasized and stated the words housing policy and housing are used in the 4th schedule in respect of national and county government functions. Now, the mandate of the national government involves the accreditation, regulation, and promotion of quality assurance and technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within the counties. So that, my lord, housing matters are an exclusive preserve of the county governments. My lord, in further interpreting paragraph 8, part 2 of the 4th schedule, I invite the court to apply the principle in Tinyefunza versus Republic, whereby the Constitution is to be interpreted as an integrated whole, with each provision complementing and supplementing each other. Now, my lords and my lady, you'll be told that housing function is a socio-economic right under Article 43 of the Constitution, and hence it is a preserve of the national government. Now, I submit, my lord, whereas housing is one of the socio-economic rights under Article 43 of the Constitution, the Constitution is expressed when it lays emphasis on these socio-economic rights that are to be co-shared between the two levels of government. My lord, in fact, if you look at Article 204.2, for example, it specifically introduces the Equalization Fund. And it states, my lords and my lady, permit me to read, the national government shall use the Equalization Fund only to provide basic services, including water, roads, health facilities, and electricity to marginalized areas, to the extent necessary to bring the quality of those services in those areas to the level generally enjoyed by the rest of the nation so far as possible. So that in this provision, my lord, the services referred to are also contained under Article 43 of the Constitution. But in this case, the Constitution has gone further to specifically delimit these particular functions to denote that they can be co-shared between the national government and the county government. Now, my lords and my lady, secondly, Section 2 of the Finance Act introduces income tax on income generated from digital platforms. My lords and my lady, I submit that Article 209 restricts the nature of taxes to be imposed by the national government and restricts it in form of imposing entertainment tax, so that the digital platforms income encroaches on entertainment tax under Article 209 of the Constitution, so that again the Act itself encroaches on the mandate of the county government. My lord, again, under Section 2, the digital content monetization as defined under the Act is ambiguous and uncertain, my lord, and the same is contrary to Articles 186.2 as read with Article 209.3 of the Constitution. Now, I refer the court to the decision in Real Deals Limited and 3 others. That is authority number 3 in my bundle of authorities, and more specifically, page 56 of my bundle, and that is paragraph 72. And I urge the court to uphold the holding that, in my view, this is the court speaking, the respondents cannot be allowed to usurp the mandate and powers reserved to another state organ under the guise of collection of revenue for the country. My lords and my ladies, again, you will be told that the speakers made a decision and determined that the bill does not involve the counties. I submit that the determination of whether a bill concerns county government is not an exclusive preserve of the speakers of the two houses. This court has the ultimate powers pursuant to Article 165 of the Constitution to determine and make a pronouncement on that question. So that in this case, that decision is being treated as if it is a private affair between the two speakers. But we submit that is a decision, an administrative decision, that is subject to review by this honorable court. And hence, this court reserves the exclusive jurisdiction to determine the validity of a decision by the speakers made under Article 110, Subclause 3 of the Constitution. My Lord, now on taxation, on the second limb of my submission, first I begin by saying that it is trite law that legislation needs to contain certainty and clarity. So that this principle, my lord and my lady, has been described as a fundamental tool in the legislative process. Now, permit me, my lords, to refer the court to the article by one author, Alexander Deming. It is titled Certainty and Uncertainty in Tax Law. That is a Siberian Federal University Journal publication. Now, my lord, I refer specifically to page 133 of my bundle, where the author identifies 4 key elements underpinning clarity in taxation law. Permit me, my lords, to read. First, the author points out that certainty in law is the cornerstone of the state governed by the rule of law. The lack of certainty in law deprives it of its ability to perform its functions effectively, to form a stable legal order, and to direct, in bracket, guide people's behavior in particular. And then, finally, the principle of certainty of taxation is the ideological basis of all modern taxing systems. Now, secondly, my lord, permit me to refer also to the 7th article on my list of authorities. That is Daniel Dick. The article is titled Neutrality and Legal Certainty in Tax Law and the Effective Protection of Taxpayers' Rights. This is an Acta Juridica Hungarica, Budapest journal publication. So that for that article, I refer the court to page 163 of my bundle, where the author points and says, taxpayer rights can be exercised effectively in a well-established system of tax law. It is important to look for the quality of tax legislation, in other words, to know about the conditions in which the tax law can be considered as ideal. It should apparently rest on a sound normative basis. My lord, the other authorities I also wish to rely on and articles, but the upshot of the submission, my lord, is that tax legislation has to be certain. So that in applying these principles, my lord, if you look at, for example, the housing levy, first, what is apparent from the responses tendered so far is the definitional challenge. We don't know, the taxpayer does not know whether it is a levy or a tax. What is it? That is the first definitional challenge, which ought not to be the case for any taxing legislation. Secondly, the imposition and enactment of that provision ought to have involved both houses of parliament. Again, the housing levy is uncertain on the mechanisms that will be used to achieve affordable housing. It fails, for example, to disclose how the funds will be computed, raised, disbursed, and utilized, my lord. Again, on the final issue, on the legality and constitutionality of the Act, I quickly point out to Section 33 of the Act, which introduces VAT on compensation. So that in that context, my lord, Section 33 is contrary to Article 24 of the Constitution, as it introduces a limitation on the right to property under Article 40. And it does not pass the threshold for limitation of rights. Finally, as I conclude, my lords and my lady, I urge the court to allow the petition, and I invite the court to reiterate the findings by the Supreme Court in the matter of the Speaker of the Senate, that is authority number 10 in my bundle of authorities, where the Supreme Court was emphatic and stated as follows: it emerges that Kenya's legislative bodies bear an obligation to discharge their mandate in accordance with the terms of the Constitution, and they cannot plead any internal rule or indeed any statutory scheme as a reprieve from the obligation. Then secondly, the Constitution vests the legislative authority of the Republic in Parliament. Such authority is derived from the people. And finally, my Lord, pursuant to Article 93(2) provides that the National Assembly and the Senate shall perform their respective functions in accordance with the Constitution. So that as I close my submissions, my lords and my lady, any legislative process that falls short of the constitutional muster can be best described as legislative deception. That's all, my lord.
Thank you very much.
Thank you, my lord. My lord, I'll make 5 highlights. My lord, I make 5 highlights, relying for the rest of the argument on my written submissions. I'll highlight the issue of regressive taxes, the statutory instruments question. I'll take you through the public participation issue, my lord. And lastly, the climate change violations. My lord, and then I'll conclude with the issue of money bills and money bills concerning counties. My lord, beginning with the issue of regressive taxes, Article 10, 21(3), 201 demand that taxation must be fair. In the Charles Macharia case delivered last week by the Supreme Court, the court restated the Article 21(3) obligation of all state organs to redress the needs of the vulnerable. In that case, children in juvenile justice, in this case, the poor in taxation. My lord, the World Bank, in its June 2023 economic update for Kenya, indicates that Kenya has been beset by an economic polycrisis because of the worst drought in 40 years, because of the lingering effects of COVID-19, and because of the ongoing global economic meltdown. The National Treasury acknowledges that. If you look at page 94 of the 2023 BPS, the National Treasury tells us that for the first time in 5 years, the rate of inflation is above the government target. First time in 5 years. And what is the impact of that? It pushes millions into severe food insecurity, my lord. And that set of circumstances has a legal effect. It invokes Article 10, social justice, protection of the marginalized. It engages Article 21(3), measures to protect the vulnerable. It invokes Article 201, equitable and fair tax measures. Lord Adam Smith and Atia Waris, whom we've cited in our bundle of authorities, explain that fairness, the word used in Article 201, demands that one must pay in proportion to their income. And so, my lord, Mr. Sore, my friend, will tell you that this is theoretical, but there's something called a regressive tax. A regressive tax is not fair because it pushes the burden to some people more than others. It affects the poor disproportionately. My Lord, in 2018, the National Treasury confirmed that doubling VAT on petrol violates the rights of others because it increases hardship, it reduces disposable income. And the other thing that BPS tells you, my Lord, is that the poor spend more than 60% of their income on food. Ordinary households spend about 54%. It is in the BPS. And so, when in an economic polycrisis, where government is saying that there's a runaway inflation, life has become hard, then you double VAT on the cost of petroleum. You impose excise duty on fish. You target milk specially formulated for infants. You impose excise duty, my Lord, on powdered juice, foodstuff. Then that is a regressive tax. My Lord, it's reminiscent of 1 Kings 12:12, where the people tell King Rehoboam that we are suffering, can you lift our burden a little? But he says, I'll double it. That is what happened here. I turn next, my Lord, to the argument that the National Assembly makes. It says that these are policy issues. Do not go into them, so that you do not interrogate the fairness of the taxes imposed by the Finance Act 2023. The same argument was made in William Musembi. Policy is mentioned 23 times in that judgment, in that case, which I argued. Same issue, dressed as political question doctrine, is made in the CDF case, again, which I argued. The Supreme Court had the CDF case. My Lord, the Finance Act, even if you could not determine issues of policy, the Finance Act is an act. It is not a policy. What you cannot do is decide which policy option the state should make. But once the state makes a policy decision, then it's justiciable. Under Article 10, anyone who formulates a policy or implements a policy, or under Article 165(3), anything done or said to be done under the Constitution. And so, my Lord, that should get rid of that argument. I turn to the climate change issue, my Lord. Now, they increase excise duty on glass bottles and on paper packaging. What is the impact? The impact on increasing excise duty on paper packaging, imported paper packaging, is to pile pressure on our forests, is to make people to resort to unclean options like plastics. That violates or threatens Article 42. And it is irrational, my Lord, considering the Climate Change Act 2016, and that this year Kenya has hosted one international conference on climate change and will in November host another on reducing plastic pollution. Yet, this is the year that the National Assembly chooses to impose excise duty on glass bottles, on paper packaging, and to increase VAT on natural gas, a clean energy option. Please find that those climate-leaning amendments violate the right to clean and healthy environment. My Lord, permit me to turn briefly to the money bill question. Now, if you look at Article 109, the entirety, a bill can be introduced in any house. But under 109(5), a money bill may be, the word is introduced only in the National Assembly. The National Assembly, the Attorney General, KRA, take the word introduced and magically transform it to debate. They say that a money bill can only be debated in the National Assembly. My Lord, that would violate Article 96 because, and the Constitution cannot subvert itself. So you must harmonize 96, harmonize 109(5), and harmonize
another article, that is Article 114. Article 114.2 explains why the Constitution demands that a money bill may only be introduced in the National Assembly. And that is because under Article 114.2, National Assembly is given an initial filtering role. One of the few, if not only, situations where the Constitution directly imposes a duty on any committee of Parliament. You will not find it anywhere. Under Article 114.2, the National Assembly must proceed only in accordance with the recommendation of the relevant committee of the Assembly after considering the views of the Cabinet Secretary responsible for finance. That is why 1095 says you can only introduce a money bill in the National Assembly in accordance with 114. 114.2 says when a money bill comes in, you can only proceed after considering the views of the committee one and the committee itself after taking into account the views of the CS for Treasury. My Lord, that reading is constitutionally compliant. It honors the obligation of the Senate to protect counties. It honors the role of the National Assembly to play that initial filtering role, and it respects the value of bicameralism. My Lord, what can affect counties more than their revenue? If, my Lord, this is an argument accepted by the Supreme Court. In the CDF case, the Supreme Court was told that look at the objects of this amendment bill. It has nothing to do with counties. It does not mention counties. But the Supreme Court found that the CDF Amendment Act, not the entire act, my Lord, the Amendment Act, was a matter concerning county governments because it impacted county revenue. My Lord, under Article 102, revenue raised nationally is shared equally among national county governments. So the more the Finance Act raises, the more counties have to share with the national government. The less it raises, the less they have. The Finance Act is a matter concerning county government. And my Lord, it's not just about that revenue. The other things they put in there, housing, statutory instruments, including those made by counties. And my Lord, I turn next to the statutory instruments issue, repeal, the Statutory Instruments Act, whose Section 21 is repealed by Section 88 of the Finance Act. First, it is not a money bill issue. It shouldn't have been in the Finance Act. My Lord, if you look at the list of the statutory instruments, page 56 of our amended petition, you'll find there the Witchcraft Act, Cap 67. What does the Witchcraft Act have to do with finances? Mr. Sore will tell you that because of 114, these are incidental matters. They can go into a money bill. But the Witchcraft Act, my Lord, how is it incidental?
Probably the chief will have just one.
Yes, my Lord. My Lord, the Subordinate Courts Separation and Maintenance Act, my Lord, I beg my colleagues to just allow me 3 minutes to finalize. The Subordinate Courts Separation and Maintenance Act, Cap 153. What does that have to do with taxes, with levies? It is not a money bill issue. The Telegraphic Press Messages Act, Cap 512, which you find at page 62 of our amended petition. My Lord, I wonder when the last time my Lord heard of a telegraphic message. In short, they put non-money bill issues into the money bill, the Finance Act, and this is why they did that. In May this year, an Annexure CN 1, 2, and 3, you'll find a resolution and answer debates by the Senate refusing to extend the life of some 1,700 statutory instruments whose term had expired under Section 21 of the Statutory Instruments Act. My Lord, that stage automatic expiry has a constitutional value. If you look at Article 96(4) of the Constitution, delegated legislative power is limited. It's limited because Parliament itself is exercising a delegated power. And so when it gives it to the Cabinet Secretary, it must retain some control. And so the power to make delegated legislation is controlled. Section 4 of that Act, the Statutory Instruments Act, requires mechanisms, my lord, to ensure the ongoing review of statutory instruments to ensure their continued relevance. Regulations made under the Witchcraft Act, my lord, still bind the Kenyan people. You'll find regulations made under repealed acts. The law is that if you repeal a statute, the regulations continue unless separately repealed. And so, my lord, the purpose of Section 21 was to ensure the ongoing usefulness of statutory instruments. The National Assembly knows this. Look at CN 5, which is the report of the National Assembly, at page 552. It's the National Assembly, I quote, notes the importance of constantly reviewing the statute book. The Senate also knows that. You'll find that at CN Roman numeral 1 at page 51 of our amended petition. The Senate says it's important to scrutinize the statutory instruments to ensure their relevance, justification, and rationale to extend their life. And my lord, they can only extend for 1 year, 12 months. And so the purpose and effect of repealing Section 21, my lord, was to defeat that Senate resolution. And you'll hear the Senate Speaker telling you that they had agreed with the National Assembly Speaker that this bill did not concern the Senate, despite this amendment. And so, my lord, find that one unconstitutional. Look at the Queensland Statutory Instruments Act 1992. It explains also the rationale for staged expiry in a manner that concurs with what the National Assembly and the Senate say. My lord, allow me to conclude with the issue of meaningful public participation. My lord, you decided the CIC case. Justice Odunga decides Robert Gakuro. There are other decisions. And my lord, we are not saying that every view presented must be adopted. No, that is not the claim here. We are saying that every view presented must be considered. That is the law. My lord, that is the law in BAT Supreme Court. That is the law in the GIFT principles, the global initiative for financial transparency, which Kenya has signed up to. It's also the law in the OECD principles, clarity of subject matter, my lord, complementarity. The view presented must be shown, must be considered, and the state organ must demonstrate how they took into account that view or why they rejected it. My lord, look at page 398 and 399 of CN5. You'll find this remark. The committee rejected the proposal by LSK, full stop. Rejected why? Was there a better view? Was LSK disliked? Rejected why? My lord, page 467, Okoa Uchumi, the people I represent, the committee rejected the proposal, full stop. Rejected why? What is the reason for rejecting? Trade Union Congress is a petitioner here. Page 469, the committee rejected the proposal, full stop. My lord, the report does not show that every submission given was considered. My lord, there's worse. The KRA at paragraph 44 tells you, 44, that the National Assembly considered all views given, but 44 times, CNX 5, the CFA and Twaweza counted and found 44 submissions left blank, without a reasoning, without indication of what happened to that 44 times. And my lord, about 80 submissions cannot be accounted for. What happened to them is not known. And so, my lord, we submit that there was no meaningful opportunity for balanced influence on the decision. The last one, Okoa Uchumi, page 316 to 361, makes 57 submissions, nearly 60. Only 4 are recorded. Of those 4, 2 are marked as the committee rejected the submissions. My lord, there was no meaningful influence, meaningful opportunity for public influence. Thank you so much, and I apologize to my colleagues for exceeding the time.
Ogada. Evans Ogada for the 6th and 7th petitioners. Your lordship, your ladyship, I pick up from where Senior Counsel Otiende Amolo left, and he equated this court to the bastion and bulwark of constitutionalism in this country. Quickly, in terms of comparative constitutional law, the year is 1919, August 11th specifically, whereby the Weimar Republic ushers a new constitution after the fall of Germany. That constitution is important for this reason. It had a Bill of Rights, and it properly recognized the individual as the locus of authority, just like our Constitution 2010. That constitution had a shelf life of 3 years. It failed. Why did that constitution fail? For these reasons. One, it was deliberately undermined by legislation under it. Two, it was deliberately undermined by political action. Your ladyship, your lordship, you are the bulwark, the bastion of constitutionalism. And we have submitted to you our authority number 1, page 1 to 72 of our bundle of authorities, that legality, the principle of legality, is one of the tools that the judiciary uses to examine the acts of state. Your lordship, Justice Mugambi, you asked a question on public participation. It has been flogged enough, but I want to give precise bullet point answers. Public participation is a principle enacted to address limitations of representative government. Therefore, if I had time, I will take us to the history of democracy in its incipient stage, whereby we used to sit as Africans around tables and make decisions through consensus. There's a tool called the Boule, B-O-U-L-E. The Greeks had the Agora, whereby decisions were made from a small platform. That is what public participation intends to do, to take us to that environment where decisions were given meaning and at least accounted for. Secondly, your lordship, legislators do not always represent the views of the people. In theory, they are supposed to. In fact, they do not. Our first past the post electoral system has ensured that certain ethnic minorities are excluded by the majoritarian interests, and therefore they are dominated, excluded from governance. That is why public participation and the need to account for the views given is important. The mechanisms that facilitate effective public participation ensure that these people are respected. They are included in the democratic cog. I will not belabor public participation further. There is the BAT case that issued guidelines. I had a position here that Parliament is considering legislation on public participation. I take a different view. Once the Supreme Court has synthesized and distilled the elements of public participation, given as constitutional law, qua Article 94 of the Constitution, that is law. Parliament has no business legislating on it. So the guiding light for this court, in terms of what amounts to public participation, we go to the BAT case by the Supreme Court. And the Supreme Court, echoing what George Vincent Odunga J in Ex parte Gekuru, those two decisions give a conjunctive test. There's a qualitative and quantitative element to public participation. Those elements have not been met. I simply move next to the impugned notice by the Cabinet Secretary in charge of housing, ostensibly in exercise of powers under Section 84, read together with Section 31 of the Employment Act. Error. Under the law, Section 2 of the Employment Act, as read with Section 91 of the Employment Act, the authority to make rules and any instrument worth calling itself a statutory instrument under the Employment Act is within the domain of the Cabinet Secretary in charge of labor matters. Not the CS Housing and Transport. I can almost bet my dime that I will be told there is the principle of collective responsibility, and therefore any CS can do what was done in those impugned notices. Those of us who studied law at second year remember the principle of delegatus non delegare potest. A delegate cannot delegate any further. So when you are a CS and statute delegates to you authority to make rules, that has to be read with the interconnectedness with Article 94. And therefore, when Parliament, through the Employment Act, specifically identifies the officer that is the Cabinet Secretary for Employment, that Cabinet Secretary cannot delegate it any further. My brother Ochiel has submitted, and others have submitted, on the Statutory Instruments Act. That act has to be read together with the provisions of the Interpretation and General Provisions Act. The following provisions complement the provisions of the Statutory Instruments Act. Your Lordships, Your Ladyship, Section 27 of that Act. All subsidiary legislation have to be published in the Gazette and shall come into operation on the day of publication. Important. The question is, this notice appointing KRA as an agent, in addition to the shortfalls identified with the Statutory Instruments Act, impugns Section 27. Retrospective application, Section 28 of that Act answers us. I will invite the court to look at it. Section 33 of this Act, acts done under subsidiary legislation are deemed to be done under the Act which authorizes it. Again, buttressing our argument, Section 2, Section 91 of the Employment Act, the Cabinet Secretary who ought to have issued guidelines, who ought to have appointed KRA, if at all, was the Cabinet Secretary in charge of employment matters, not labor. Employment and labor matters, not housing. Section 34 requires that any instrument in the nature of rules and regulations has to be laid before the National Assembly. The notice, the impugned notice and the agency notice to KRA holds out in its Austinian sense. John Austin. We were forced to obey the command and we remit taxes or levy, whatever it's called, ostensibly because of those rules. Your Lordship, those rules ought to have been submitted to the National Assembly by virtue of Section 34 of this Act. In conclusion, and as I wind up, a lot has been said about policy, that this court ought to keep off political questions. The lead decision of Justice Joel Ngugi in the BBI case, David D. and others, ably captures the authority of this court as captured in Article 165, such that merely a threat to the Constitution is an invitation for this court to deal with that threat whenever it occurs. The Constitution 2010 baptizes this court as a Kelsenian court. This is a court that is supposed to do judicial review. And judicial review, under the context of the Constitution 2010, and reading specifically the principal provisions, Article 10, the Constitution 2010 mandates this court to even examine policy considerations, however crafted. Anything that lacks legitimacy cannot be effective. Lacking in effectiveness, they cannot develop legitimacy. Those are not my words, those are the words of Samuel Huntington, third wave of democratization in the late 20th century, attacks in political science. Basically, anything that was not procedurally proper, constitutionally infirm, cannot be a material of governance. Anything done without according to the authority of the people as the sovereign locus under the Constitution 2010 cannot be baptized, cannot be solemnized by an imprimatur of this court. We humbly submit. Thank you.
My lady and my lords, my name is Robert Kamwara. For the record, I will be relying on my amended petition dated the 9th of August 2023, my affidavit sworn on the 9th of August 2023, my further affidavit sworn on the 24th of August 2023, my written submissions dated 24th, and my supplementary written submissions dated the 8th of September in response to the first and second respondents' submission. My Lord, yes, my Lord, on my way here I had carried 4 stones, but I was denied to come with them. So I'll simply explain them and I would wish you visualize them. And my 4 stones, my Lord, one of them is openness, opaqueness, accountability, and ambiguity. I want to put section 84 on the weighing scale. And my Lord, the purpose of doing this is to demonstrate how section 84 is ambiguous. In this case, I'll be asking a question: is section 84 of the Finance Act unconstitutional? And the answer to the affirmative. This section has been enacted to ensure that there is as much opaqueness as there can be. Why do I say that? When the Finance Act, when the Finance Bill was brought to the public for the public participation, the Finance Act, the Finance Bill in itself stipulated clearly the issues that through the Employment Act would be amended and the benefits that the members of public, those who are employees and employers, would benefit from. I'll read in brief, in the small titles that are the marginal titles. One of the things that was supposed to be amended was that there would be a national housing fund, a national housing development fund. My Lord and my lady, on the enactment of the Finance Act, nothing like this was demonstrated. Further to that, the Finance Bill was clear, and it had stated that employees were to qualify for affordable housing. And who are these? It clearly stated, and it is said that employees would benefit and they would be financed for purchase of a house. The Finance Act that came out, my Lord and my lady, did not have that. The Finance Bill further was clear on how funds would be transferred back in the event that somebody retired and did not need to use the monies that he had paid from his employment. The Finance Act does not address that. It's clear that the space between the finance bill up to the time of the enactment of the law, there was a lot of ambiguity that took place. No openness came out, and we can comfortably say that the act is purely ambiguous. It is meant to confuse. Initially, it was very clear, but later was meant to confuse Kenyans. Article 10 and Article 201 on principles of public finance, the Public Finance Act clearly states that everything should be open and there should be no opaqueness in anything. There was no transparency, bearing in mind that the Constitution has only provided for 4 kinds of taxes. That is the income tax, VAT, excise, and customs. We are blind to where this housing, affordable housing levy should be allocated. Fine. The legislators are saying, or the respondents are clearly saying, that there is Article 209(2) that allows the creation of additional taxes. The legislators can put in new taxes. But in this case, where can we present the housing levy to? It is not clear. The first respondent, in his replying affidavit in paragraph 24 and 25, alleged that the funds were to be governed by the National Housing Corporation. However, the Act is silent. The Act does not say where the money is going to be taken to. These are a lot of funds. The month of August itself, a lot of monies were deducted from all these people who are seated here and those also in the bench. Monies were deducted from their salaries, but truly the money cannot be accounted for. I wish to now bring to your attention my second point about opaqueness once again. And Section 84 states that the levy shall be deducted from the gross pay of employees. What is gross pay? What is gross pay? The fourth respondent has attempted through an instrument which I would call a public declaration or a roadside declaration that gross pay is 1, 2, 3, 4 things. There is nowhere in the Income Tax Act that this has been properly defined. There is nowhere gross pay has been defined. In that case, the public finance management legislation states that there should be clarity, and the purpose is to collect as much as possible. We can tell the reason why the Finance Act put in the affordable housing is purely just to collect money, monies that cannot be accounted for. Therefore, we can say no accountability, despite the fact that we want to collect as much using the ambiguous methods of collecting cash. I'll rely on my bundle of documents on paragraph 24, Republic versus Commissioner of Domestic Taxes. And my lord, on this, I'll rely on the Bidco Oil Refineries versus Attorney General. In the judgment, it was clear that it is within the authority of the legislature to enact legislation governing the manner in which particular form of taxes is to be administered, including the manner in which it is to be imposed. Therefore, the legislation or the legislature did not cover or did not undertake its work to fully ensure that Article 210, to ensure that the taxes that were being created were properly collected. Article 201 and Article 10 then can clearly be seen to be infringed, because in Article 10, accountability, national values, good governance on how the funds are going to be utilized does not seem to be coming out. Further, I wish to demonstrate that in Section 84, there was a lot of ambiguity because the fifth respondent purported to appoint the fourth respondent. However, it should be the vice versa, where we have the CS Treasury who should be appointing Kenya Revenue Authority and not the CS of lands appointing Kenya Revenue Authority to do the collection of tax. Under what law was the appointment done? It is clear that there is ambiguity and that there was no clarity on those issues, and therefore the reason why they had to quickly try and circumvent and get the Commissioner of Income Tax putting up something very fast to collect the funds. The first and second respondent justifies the appointment of the fourth respondent on basis of Section 75 of the PFM Act. But my lords and my ladies, this is not right. Only the CS of Finance can appoint the fourth respondent to undertake collection of revenue, and in that way then, this was a true intervention, a true contravention of the law. This was actually intentional, I would say, to create more opaqueness on the violation of Article 10, violation of Article 201, funds taken away from members of public from hard-earned money being diverted into accounts that cannot be explained, rightly denying the right of property to members of public, and defying and infringing Article 40 of the Constitution. It's actually unconstitutional and pointing to the fact that there is a lot of opaqueness on this issue. The Statutory Instrument Act also clearly... Thank you, my lord. Sorry for that. The Statutory Instruments Act in Section 5 breathes life into Article 201 of the Constitution, where we say that public participation should be actually undertaken when you want to enact any document, like the guidelines for KRA. This was not undertaken. So, my lord, I wish to submit that the Section 84 of the Finance Act be declared unconstitutional, and therefore we pray that the petition be prayed as allowed, and I wish to thank you, my lord.
May it please my lord, my lady, my name is Ongoya. I appear for the petitioners in petition number 234 of 2023. In summary, my lord, my lady, the petitioners rely on the amended petition dated 10th August 2023 and the supporting affidavit of Dr. Charles Muhwaya of the same day, as well as the written submissions and the list and bundle of authorities, all dated 5th September 2023. In the interest of time, I adopt the averments in the petition, the depositions in the affidavit, and the contents of the written submissions, and wish to highlight the following brief aspects. Number one, this petition brings on board the voice of the workers in this dispute. If the Finance Act 2023 shall go down in history as an oppressive piece of legislation to the Kenyan public, then the most oppressed, the core of the oppressed in that statute shall be the workers of this country, as I will demonstrate shortly. There are two aspects that these petitioners focus on in their challenge of this legislation, and that is number one, that part of the Finance Act, that is Section 26, that amended the Income Tax Act to increase certain individual income taxes. And number two, Section 84 of that Act, which amended the Employment Act at Section 31B, so by introducing Section 31B. Allow me, my lords and my lady, to begin by laying the constitutional basis of this challenge. I will start with Article 19, Clause 3b of the Constitution, which provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. Then paragraph C, which provides that those rights and fundamental freedoms are subject only to the limitations contemplated in this Constitution. It follows, therefore, that the rights of workers that are provided for in, among other statutes, the Employment Act, form an integral part of the Bill of Rights by instrument of Article 19, Clause 3, Paragraph B of the Constitution. And therefore, if one wants to limit the rights of workers as set out in the Employment Act, they must comply with the criteria for limitation that is spelled out in Article 24 of the Constitution. And this is what then Parliament does in enacting Section 84 of the Finance Act. It amends the Employment Act by inserting Section 31B, which provides that notwithstanding the provisions of Section 32A, B, C, and D of the Act, this is a very egregious part of this statute, because this is what the statute does. Section 32A, B, C, and D of the Employment Act removes certain persons from the application of the Employment Act. It says if people employed under the Armed Forces Act, under the Prison Service Act, and the National Police Service Act, and that act, the Employment Act, does not apply to them. What Parliament does in the Finance Act is to bring them back to the Employment Act for the limited purpose of taxing them. It says we shall bring it, notwithstanding sections 3, 2A, B, we shall bring you back for the limited purpose of levying the housing levy on you. Then disapply the rest of the provisions of that act in terms of the other rights of employees to you. It's the only statute I know, my lord, that imposes only obligations on a subject and expressly denies them corresponding rights under the same law. That is the Finance Act that is being litigated before you today. But in the interest of time, what is the net effect of these two provisions that we have singled out? The Trade Unions Congress appeared before Parliament and has come before you and said, look, there is Section 19 of the Employment Act that ring fences, that protects wages and incomes of employees from unregulated deductions. All of them, including statutory deductions like taxes. And it says, okay, we are going to allow the following categories of deductions. But says, whatever you do as the deducting agency, the employer, if you may, do not effect deductions on the salaries of an employee so as to leave an employee with anything less than 1/3 of his income. So the Trade Unions Congress goes before Parliament and says, look, if you wantonly introduce new taxes targeting employees, as you have done in Section 26, increase the Income Tax Act for certain bands of employees, and through introduction of Section 31B of the Employment Act, introduce a new tax, the housing levy, what you do is that you are adding them to the existing deductions, and the employer has no choice over these ones. Address yourselves to that question. Apply your mind to it, that what is the effect of these consequential amendments to the protections under Section 19 of the Employment Act. My learned colleague Ochel Dudley summarized for you what the Parliament said. it said that invitation is rejected. Why? Are you saying that it's nonsensical? It makes no sense completely. Are you saying that when stakeholders tell you that apply your mind section 19 of the Employment Act, they are being irrelevant in the considerations that they are inviting you to apply? It's that kind of arbitrariness where an invitation of this nature is rejected by a wave of the hand with no reasons supplied that delve a debilitating blow on the constitutionality of these provisions of the Finance Act. They render provisions on public participation illusory. They have no effect. My clients at least expected reasons on why these invitations take into account the provisions of Section 19 of the Employment Act were not taken on board. But more importantly, when we bring the matter before this court, what do the respondents tell this court in their replies? They say no. The duty to ensure Section 19 is complied with is not that of we, the lawmakers. That's in complete violation of Articles 20 and 21 of the Constitution that make it the obligation of every person to ensure respect for rights and freedoms. So it says it's not the obligation. It is the obligation of the employer. And two, it is for the employees. That's what they are saying in their responses before you, to go and negotiate with the other lenders, the people they owe the Shylocks, to rearrange their deductions so that they remain within that minimum 30% rule. It is not the obligation of Parliament to take that into account. I submit respectfully that the state's obligations to protect its citizens was highly compromised by that attitude on the part of the lawmaker as they made this law, and on their part as they responded to the petition before this court. Allow me to also address the impact of Article 24, Clause 2A of the Constitution on the matters before you. Article 24, Clause 2, Paragraph A, provides that despite Clause 1, that is the clause on how rights can be limited, a provision in legislation limiting a right or a fundamental freedom in the case of a provision enacted or amended on or after the effective date, as is the case of the Finance Act here, is not valid, that's what I'm emphasizing, unless the legislation specifically expresses the intention to limit that right or fundamental freedom and the nature and the extent of that limitation. We submit that an employee has proprietary interest in his income. An employee's income is an employee's property, duly acquired after laboring for the period of labor for which he is paid. For the lawmaker to enact provisions in the nature of Section 26 of the Finance Act and Section 84 to take away a part of that property, by law, compliance must be had to Article 24, Clause 2, Paragraph A of the Constitution. We invite you to look at that law, and you will realize that in terms of the bill, the proposal to enact that law in the nature of the bill, it lacked that specificity in terms of specifying that it intended to limit employees' property rights within the meaning of Article 40 of the Constitution. And what the Constitution says is that if that happens, then that legislation is not valid. It's against this background that the petitioners in petition number A234 invite you to declare that sections 26 and 84 of the Finance Act are invalid and of no effect, and to strike them out accordingly. In addition to all that, I invite you, my lords, to look at our written submissions that explain those points in detail, and we rest our submissions at that juncture. Thank you so much for the audience.
We now go to E237 E237 of 2023. This is the petition by Frederick Onyango Gola and others.
Thank you very much, Your Lord and Lady. My name is Professor Fred Ogola, first petitioner in the petition E237 of 2023. I'm not a lawyer, but I'm a governance expert, so that's the angle we're going to take. I place my reliance on the petition that we have filed, our written submissions, and the accompanying list and bundle of case digest. I seek to answer 4 questions for my submissions today. And the questions I'm going to give for the whole submission today is whether the imposition of VAT on insurance compensation is unconstitutional. The second question is whether the Finance Act and all certain provisions in the Finance Act are unconstitutional. The third question is whether there was sufficient public participation in the process leading to the enactment of the Finance Act. And the last question I want to raise, Your Honor, is what are the roles and duties insofar as the petition that is before you is concerned. So to start with, VAT on insurance compensation. Instances where VAT may be imposed are as follows. With regards to imposition of VAT on insurance compensation, in answering the question whether insurance compensation is eligible or not, VAT must be subjected as insurance compensation is not a consumable, if you like, a service or good, and therefore they should not be taxable as they are being subjected to the current tax with the Finance Act. So to the extent that you find that it is inevitable to find that insurance compensation is not a consumable good or service supplied, you must therefore reach out an inevitable conclusion that the imposition of the VAT on insurance compensation in the Finance Act is in violation of the Constitution of Kenya 2010. The second question is on the unconstitutionality of the various sections of the entire Finance Act. In addressing you on this issue, my lady and lord, I submit that your duty and obligation under this issue, insofar as the case of the petitioner is concerned, is to interpret the Constitution and apply the Bill of Rights. In applying the Bill of Rights, you are mandated and obligated to adopt an interpretation that most favors the enforcement of a right or fundamental freedom contained in the Bill of Rights as directed in Article 23, Clause B. You are also additionally required to utilize and apply the constitutional principles on interpretation of the Constitution under Article 259, which requires you to interpret the Constitution in a liberal and purpose approach in a manner that protects and promotes the purpose and principles of the Constitution. Your Honor, I'm not just a consequentialist where consequences determines what people should do, because that is a happy path. But more specifically, we have to say that we submit that we have to look at the 2 parts where we talk about both purpose and the effect of any legislation, because sometimes the effect can be good, but the purpose is lost. What then was the purpose of the Finance Act? By its name, it's an act that helps the government raise finances to cater for its budgetary expenses for financial year 2023-2024. The petitioners, in the petition before you, is agreed by the effect of the said act on the Constitution, which I now proceed to address you as follows. 1, all of us in this room might know that it's been stated that this Finance Act was the most popular act in the history of Kenya. Without evidence, I don't want to go there, but all we know that it was least intellectually debated, as my colleague said, reject, reject, reject. There was no intellectual discourse. So on the public participation, on the face of the petition that is before you, we have shown and demonstrated that the certain sections of the Finance Act were amended when the Act was still a bill before the floor of the House of the third respondent, that's the National Assembly. Honorable members of the court, public participation is a constitutional requirement under Article 10, Section 2 of the Constitution. Consequently, I invite you to find that the extent that the in-punch clauses, which we have stated, were introduced to the bill and are not subjected back to public participation, in their express view, the said sections are violative of the constitutional principle of public participation, which serves the purpose of informing the public of what is expected and to their concerns and fears. The second one, on discriminatory nature of the housing levy in contravention of Article 27 and 43 of the Constitution of Kenya 2010. My lords and ladies, the housing levy as passed under the Finance Act requires mandatory contributions from both the employer and employee. It means, therefore, the right to housing provided for under Article 43, Section 1 of the Constitution of Kenya 2010. The effect of this is that only the persons who are employed will have the benefit of being able to have the right under Article 43, Section 1 of the Constitution enforced. Only persons who are employment, thus violation of constitutional rights, principle of non-discrimination on the grounds which is contrary to Article 27, Section 4 of the Constitution. My lords and ladies, as I finish my submissions, which of course you see is precise, I would like to urge you not to bury your head from the issues affecting Kenyans, like the Court of Appeal did at the Supreme Court already. Just do the right thing. Don't be scared of the injustice already done by the higher courts, because we believe that from the low courts you can get justice, and sometimes justice appears as you go the sky above. And I would like to plead to you that you might be able to consider the plights of Kenyans who are suffering in these taxes as being listed here in many ways, and the inconsistencies in it that we make before you. With those few remarks, I urge you to allow the prayers sought in the petition number E237 of 2023 as prayed. I thank you, my lady and lords, for listening. Thank you.
Thank you very much. There was a Mr. Jerry Owol in the same matter.
Okay. Yes, he was in the same petition.
Okay, since he's not here, we move on to the next. E254 of 2023, Mr. Arwa. And Mr. Arwa, you're eating into the time of the interested parties.
My lords and my lady, in that matter, as I indicated earlier, I appear together with my colleague, Ms. Adunga, for all the petitioners. Unlike all the other petitions, this particular petition challenges only one provision of the Finance Act, specifically Section 47, Paragraph A, Subparagraph Roman 12.
Section
47A, Roman 12. My lords and my lady, the position of the petitioners is that this particular provision is unconstitutional and should be declared as much. The main reason why the petitioners contend that it is unconstitutional is because it was never contained in the bill that was published on 28th of April 2023 and which was submitted to public participation. My lords and my lady, there are several other issues that we intend to raise, most of which have already been touched on, and therefore I will not dwell on them. I'll only touch on the aspects of our submissions that have not been submitted on by my other colleagues. And specifically, my lords and my lady, I will be addressing basically 6 issues. Number 1, how do constitutional values implicate the legislative process? Number 2, what amounts to a bill for purposes of Article 109 of the Constitution? Number 3, what does public participation in legislative process entail? Number 4, what does amendment of a bill actually entail? 5, what is the implication of the impugned section on the right to health? And finally, what is the implication of that particular legislative provision on socioeconomic rights entrenched in Article 43 of the Constitution? So I will start with the first issue. The implications of constitutional values on legislative process. And my lords and my lady, I submit that this is not an idle point. I will start with Article 10, Subarticle 1, Paragraph B. And this is what it says. National values and principles of governance in this article bind all state organs, state officers, public officers, and all persons whenever any of them, in Paragraph B, enacts or interpret the Constitution, any law or the Constitution. My lords and my lady, the substance of my submission is that these constitutional values bind Parliament. And every step they take in the legislative process must take into account these values. Specifically in relation to Section 47 that we are complaining about, it is admitted by all respondents that it never featured in the bill. And if you read Paragraph 10 of the affidavit sworn by Samuel Njoroge on behalf of Parliament, he clarifies, my lords and my lady, that when the bill was at the committee stage, some proposal was presented to the committee. And it is this proposal that was eventually passed into law. Essentially admitting, my lords and my lady, that this proposal was introduced on the floor at the committee, at the third reading stage, sorry. And that, my lords and my lady, you will see in Paragraph 10 of the affidavit sworn by the Speaker of the National Assembly. So the question, therefore, is whether a bill, a proposal which is introduced at that late stage can be enacted into law without being taken back for public participation. And our submissions, my lords and my lady, is that it is not possible. And it's important to note, my lords and my ladies, that Parliament was very much aware of that. I invite my lords and my lady to look at pages 80, 81, and 86 of the report that was presented by Parliament and annexed to the affidavit of Samuel Njoroge. In those 3 pages, you will see that Parliament actually rejected other proposals that were introduced for the first time at that stage. Meaning that they were, and the reasons given was, these matters have not been taken for public participation. So what we see here, my lords and my ladies, is a situation where Parliament selects which new proposals to enact into law and which new proposals to reject for failure to comply with public participation. And it is our humble submissions, my lord and my ladies, my lords and my lady, that Parliament cannot do that under our constitutional dispensation. Specifically, Article 10 entrenches the value of integrity, the value of transparency, the value of equality, and the value of good governance. All these values bind Parliament. The value of integrity cannot permit Parliament to choose which new legislative proposals to accept and which new legislative proposals to reject. They must act with integrity. And this is a constitutional imperative. Secondly, my lords and my lady, the value of transparency requires Parliament to explain to Kenyans on what basis they reject some new proposals and on what basis they accept other new proposals. It is a duty which they have to explain to Kenyans why some new proposals are being accepted and others are being rejected. Otherwise, we are going to encourage impunity and arbitrariness in our constitutional dispensation. Thirdly, my lords and my lady, Parliament owes a duty to all Kenyans who submit proposals for their consideration. And where 2 Kenyans submit new proposals at that late stage, it is not fair for Parliament to choose to treat one of them differently from the other. So all the stakeholders who submitted new proposals at that late stage were entitled to be treated equally. And it is not for Parliament to decide which one to be given favorable treatment and which one to be rejected. And finally, my lords and my lady, our submission is that Parliament, after all, does not have the power to selectively choose what to accept and what not to accept when they are all submitted at a very late stage. Those constitutional values bind Parliament, and where Parliament acted in clear violation of such values, then whatever it does amounts to a nullity. Well, the second issue is, what is a bill for purposes of Article 1? My Lord, allow me just to wind up. My submission on this front is that every legislative proposal must be contained in a bill. And that means that it is what is already contained in a published bill that can be submitted for public participation. It is therefore inconceivable that a new proposal can feature for the first time in an act of Parliament, my Lord. Section 47A that we are complaining about will not be seen in any of the versions of the bill. And you have them before you, my Lord. It features only for the first time in the Act, meaning that this is a proposal that never appeared in a bill and could not have been passed within the meaning of Article 109. As concerns the issue of public participation, my Lord, I just wish to point out that this is an issue that has been considered before, and the courts have held that where a new proposal is introduced at a very late stage, then that proposal must be taken back to public participation. And that is what ought to have happened in this case. My Lord, there is the question of what amounts to an amendment. An amendment, in our humble submission, must mean and mean only an amendment to an existing proposal in the bill. Cannot mean introduction of a new bill, a new provision that has never featured at all in the bill. My lords and my lady, therefore, it was not possible for this particular provision to have been introduced by way of amendment. And that is the same with other provisions, my lord, that my colleague, Mr. Molo, had referred to, all the 25 of them. Finally, my lord, allow me to point out that these proposals have got adverse effect on the right to health and socioeconomic rights, to the extent that they will increase the cost of medicine and place the medicines beyond the reach of ordinary mwananchi, thereby violating their right to health, which is entrenched in Article 43. It is also going to make it very difficult for our pharmaceutical manufacturers to compete favorably with other global manufacturers. Now, on this point, my lord, we are aware that Parliament can pass legislations that limit fundamental rights, but they must meet the requirements of Article 24. And our submission is that that consideration never featured at all. My lords and my lady, for those reasons, we humbly urge this honorable court to allow our petition and grant the order sought. Thank you.
There was and you have now guillotine. We are on guillotine mode. We only have half an hour, and Mr. Mtata must be heard. Yes, Mr.
My name is Nekiri. I appear for the petition 211. The petitioner is one Mr. Peter Odiamba Agoro.
You have 5 minutes.
My lord, we bring our submissions in support of the petitioner's petition, which was dated on 23rd June 2023 and later amended on the 29th June 2023. The petitioner's petition was to the effect that the Finance Act was not subjected to public participation, and the outcome thereto, when the public were interviewed, the outcome thereto was not considered, because basically it was rejected on a greater percentage. And for sections that got assent of some members of the public are not the same that were eventually passed into the law. The petitioner relies on Articles 1, Article 2, Article 10, 19, 22, 23, 159, 162 of the Constitution, and they invokes all the constitutional provisions which are stated. The prayers sought in the petition are that the act be declared to have been procedurally introduced, and it is unconstitutional and null and void. The further requires that the first respondent be compelled to amend the Finance Act, to put it back to the public and have it amended to go in tandem with the Constitution of Kenya. That another prayer is that it is the act is in violation of the Constitution of Kenya, especially Articles 10 and 47 of the Constitution of Kenya. There is the introduction of the 16% of fuel prices, which was introduced by April. Such be declared null and void, and the same be suspended. The petitioner has pointed out these specific provisions that as to Section 52 specifically of the Constitution Act violates the rights to property which are spelled in Article 40 of the Constitution. Article 40 of the Constitution, my lord and my ladies, provides that the property is protected and jealously so protected, but the Act goes against such protections, breaks through to collect revenue from what was not actually introduced to anybody, to the public, and the public did not actually assent to the same. We have a question which we shall require that our petition answers is whether the respondents failed in their duty on the rule of law and protection of the Constitution. As provided, the respondents failed to protect the Constitution, they went against the rule of law, and it is a danger to the society which is protected under the Constitution. My lord, we have provided statutory provisions under which we have brought the petition, as well as cases which have previously been determined, and finding being that what was taken through what has come out as the Finance Act is actually something that is pardoning the public rather than assisting the public in it. Is the cases which we have cited include Cohen's versus Virginia, number 19 of U.S. 264, which provides that court will take jurisdiction if it should, but it is equally true that it must take jurisdiction so as to enable the legislature provide good laws. Finally, my Lord, because we have submitted this one in written, we pray that the specific sections of the law provided in the Finance Act be declared null and void, and or have the whole document declared as a nullity and be nullified by this honorable court.
Thank you.
Thank you.
We now deal with the interested parties. Any revenue authority, do you support or oppose the petition?
We oppose the petition and we are responding in all the way.
Okay, so you wait for your turn. Senate, Mr. Cecil Miller, oppose or support the petition?
We oppose, my lord.
You wait for your turn. Consumer Federation of Kenya, they're not here. Kenya Export, Floriculture, Horticulture and Allied Workers Union, you oppose. You're with Mr. Ongoya. We will take that into account. Devki Steel, Mr. Kate, you oppose or support? You oppose. And Electric Mobility Association of Kenya, you oppose. And Kenya Airline Pilots Association, you support the petition, and you have all filed written submissions. Thank you. Mr. Omtata, where is he? You were supposed to be prosecuting somebody.
Yes, I thought you could finish with the petitioners and those supporting the petition.
They have finished with them. They are interested parties. You know, they are like passengers in a bus. They either support or oppose. They have no independent right of existence. Yeah. But we will consider them. So, Mr. Umtata, you have 15 minutes to make your case, and then we break for lunch. And where is the alleged contemner? He should be standing somewhere with police so that he doesn't run away. Come and stand here so that we all see you and so that you can hear the accusations being leveled against you. Are you represented?
Yes, I am. Good afternoon.
Yes.